The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Good morning and thank you, everyone. Please be seated. We are here today for 3 oral arguments and 1 case that will be submitted without oral argument. Before we get going, I'd like to do a sound check. Justice Oxley cannot be here today in person, but she is participating remotely. Justice Oxley, can you hear me?
I can hear you, Chief.
Thank you. And we'll do the same thing once we have the lawyers, if you don't mind. We'll start with Mr. Howie, if you would do a quick sound check to make sure that Justice Oxley can hear you. Yes, please do.
Good morning. My name is Andrew Howie.
Thank you, Mr. Howie.
Okay, thank you. All right, so this morning we are also going to have submitted without oral argument the case of State versus Newman. That case is hereby submitted without oral argument. And our first case of the morning is Marriage of Pazhoor. And Mr. Howie, you may begin.
Good morning, Chief Justice and Associate Justices. May it please the Court. My name is Andrew Howie, and I represent Dr. Suraj Pazhoor, who is the applicant for further review in this particular case. Specifically, I'll get right to the end as to what my client is requesting. My client is requesting that this Court vacate the Court of Appeals decision in regard to the alimony award and completely affirm the District Court award. So let's focus upon that. My client did not appeal the District Court's alimony award. As a matter of fact, on the record, my client admitted that he should pay alimony. So this is not a case where my client is just sour grapes and doesn't want to pay alimony. He accepted the District Court's award, which was $7,500 a month for 5 years. What the Court of Appeals did, based upon Hancy, that is his former wife, on Hancy's appeal, is the Court of Appeals dramatically and unjustifiably increased that alimony award to 12 years worth of alimony, $9,000 for 7 years, which could not be modified even if she got remarried, $8,000 for 3 years, and $7,000 for 2 years, for a grand total of $1.212 million over 12 years. That is unjustified by this record and by the law of this Court and the published decisions of the Court of Appeals. So,
on how much your client would have made over that period of time?
But what it comes down to, Your Honor, is what it was basically stipulated that my client made $500,000 at the time of the divorce, and that's what the District Court and the Court of Appeals found his income to be, and we're not disputing that. But let's get to the point, is when it comes down to the 3 classes that this Court has already recognized in terms of alimony, traditional, rehabilitative, or reimbursement. 2 do not apply, traditional and reimbursement. Traditional does not apply because, 1, it does not meet the 20-year threshold as this Court articulated in Gust. Now,
Line, 20 years? So they're close to it, aren't they?
Close to it. But in the same respect, this Court and the Court of Appeals and the District Courts of the state have given significant respect to that 20-year guideline. But that's not, again, not the focus of our case. So first off, we don't have the 20 years threshold. We've got 17 years. Second, I think one of the 2 key facts of this case, what is 598.21a and what this Court has articulated many, many times, and that is the age of the parties, the health of the parties, and the ability of the parties post-divorce to become self-sufficient. So what do we have here? We don't have somebody close to retirement. Hancy was 41 years old at the time the decree was entered in this particular case. She was healthy. Now, of course, Hancy made the argument that she suffered from migraines and back pains, but both the District Court and the Court of Appeals found that those health conditions did not impact her ability to get further educated, further training, or to go back to work. So her health is not an issue. Second, by being age 41, she was arguably 26 years from retirement age. That's 26 years of her prime income earning age, her 40s and 50s, to become self-sufficient and to work toward improving her own situation. Now, what the Court of Appeals did by increasing that alimony award to 12 years, in a way takes away the incentive of being self-sufficient, okay? Because what was also in the record in terms of
Not just about self-sufficiency. Isn't it also getting her to be in the life to which she's become accustomed?
also, but that's also towards a traditional alimony award, which again, I want to reiterate, the law of this court and
Argument that, like you even used the word guideline. It's a guideline. So let's not just completely dismiss traditional as an option here.
I appreciate that, Your Honor, but this case does not fit into a traditional alimony award because I have yet to find a case, I'm sure somebody else could probably prove me wrong, but whenever there have been traditional alimony awards for marriages less than 20 years, it's because age and health has directly impacted that person's ability to become self-sufficient. And so for, and
Mr.
even,
Howie? Mr. Howie, could I
Yes.
ask, sorry, but the statute specifically says self-supporting at a standard of living reasonably comparable to that enjoyed during the marriage. And so it's not just self-supporting, it's at the level that she had been accustomed to by statute, correct?
yes, absolutely. But again, my point is that the district court gave her 5 years of alimony. So that'd get her from age 41 to 46. And again, health, age. She was able to do it. The court awarded shared physical care to the parents. So again, if we're looking at, let's look at the other side of the coin in terms of Suraj's ability, is yes, he's making $500,000 a year, but he is working full-time and also is a 50% care parent. And
Dispute largely with the duration of the Court of Appeals award, the amount. I'm assuming you're going to say both. And then could you address specifically kind of the stair-step approach that the Court of Appeals took and maybe why that would be improper or proper?
as to why the stair-step approach, especially with this case, is what you had a 17-year marriage. She'd been out of work taking care of the home for 11 years. And so kind of
I got to point that out. Out of work.
home. All right. Absolutely. We're not disputing that, Your Honor. Absolutely. Again, this is not a case where he doesn't want to pay alimony. He is willing to pay alimony. It's just that the district court's alimony was equitable based upon the circumstances of this case as applied under Section 21A of 598. To get to Justice McDonald's point, I think, Your Honor, what you brought up in your dissent in the Bacom decision, which was an unpublished decision when you were on the Court of Appeals, really, I think, provides a very strong basis for this court to adopt in doing alimony awards. And what is my point? As what Your Honor summarized in that particular case is we need to look at alimony, and this court should look at alimony more on a need-based situation in terms of what does Hancy need? Young, healthy, educated. She already had a medical degree. She said she was going to be able to get re-educated or retrained within 5 years. And then we get into the liquid assets, what Your Honor brought up in terms of transitional alimony. That when you don't really fit into the rehabilitative model, then you've got the transitional alimony model, where Hancy arguably does have the ability for self-sufficiency, and then therefore does she need it?
The liquid assets, when you add in the equalization payment, how much does she receive in investment type assets that money can be derived from those?
Your Honor, my client had to pay her $143,000 cash equalization payment out of the property. And in addition to that, she received $411,000 in liquid assets. Those were bank accounts, checking accounts. She had approximately $56,000 in an IRA and cash equivalent in life insurance. She had significant liquid assets, which gets to the analysis of transitional alimony, as Justice McDonald's pointed.
Up to that. In addition to the liquid assets, what was the value of the apartment, or were you including that?
Were not valued. I looked for that in the record. They were not valued because the party stipulated that to be premarital, and so it wasn't valued because it was automatically set aside to her. Since the court didn't consider it for division of property, it wasn't considered. But it is also an income earning asset, although it's minimal as associated with that. But yes, Hancy.
For our court to formally recognize transitional alimony, does it make a difference that it wasn't sought or argued below?
And the fact is, the reason why it wasn't sought or argued below was because Judge McDonald, when he was on the Court of Appeals, first brought it up in terms of Iowa law based upon his review of the record. I mean, I certainly don't want to speak for Justice McDonald, but there have been several cases, and the cases that I cited on behalf of my client's application for further review, where the Court of Appeals has regularly brought up transitional alimony that was never argued.
How do you distinguish it from rehabilitative alimony? It seems like this case is more rehabilitative, where you're getting alimony while she pursues a master's degree.
Honor, that when you look at the line of distinction between rehabilitative and transitional alimony, yes, this is a rehabilitative case. But again, that is why the district court awarded an equitable alimony amount for 5 years, $7,500 a month. That's $90,000 a year of tax-free income to her in just alimony.
Skirting around, I don't think you want to address it head on. You keep saying, we just need to talk about the needs. If we only talk about the needs, aren't you ignoring the fact that she would not be living the life to which she has become accustomed?
Yes, but also, why am I not talking about that, Your Honor? The reason why I'm not talking about it is these folks are getting divorced. And so therefore, divorce is finality. They are restoring their legal rights as single persons, whether they want to or not. That's part of the no-fault statute of 598, and so therefore, even if Hancy didn't want the divorce, that's where she is.
You're ignoring that aspect of the statute that says at a level. Maybe that's true from this point forward, but when that alimony is being determined, it is to be set at an amount to which she could live a life to which she's become accustomed. You wanted that to start beforehand.
And if I misspoke, I apologize. When you look at the overall structure of both these folks, it was an equitable property split. Hancy did not appeal the property. She received $411,000 in liquid assets, cash she could use to support herself. She received $40,000 of my client's 401k at the date of the divorce. So now what is alimony? Alimony is based upon future earnings of the particular parties, but as single persons. And so yes, alimony is designed to lighten the economic load that is caused from the transition from marital to single life. That's why alimony is deserved. My client didn't dispute that. He didn't appeal the district court award. The $90,000 a year award for 5 years is more than enough for self-sufficiency.
12 years, it seems as though that basically brings the children through high school. Is that your understanding of where the 12 years came from?
The Court of Appeals did not make any mention of that, and your guess is as good as mine. But I think that's also inappropriate because the court awards shared care. My client's a 50% care parent. Also, the district court ordered the parties to share expenses associated with the children. And so my client is also contributing towards the children as well. And so maybe, I mean, it's certainly within reason that's where they came with the 12 years, but does that justify a 12-year alimony award? It does not. Because I think, again, the key components of what this court has always said is how are they able to basically support themselves with this situation? What is that $90,000 a year going to go for Hancy?
In Gust, the court mentioned that alimony awards kind of in the 30% range of the difference are generally considered equitable. If you crunch the numbers in this case, what is the percentage?
I apologize, Your Honor, I didn't do that type of math. And the main reason is because of what Gust and Maurer said is that you know, that's getting towards the AML guideline amount in terms of percentages, and plus what this court has said in Gust and Maurer is we apply the statute based upon the equity and the parties at the particular time.
Those cases were pre-tax law change, right? What is your client's combined state and federal tax rate?
That's way too, I'm sorry, Your Honor, I don't know the tax rate on that, but again, he stipulated he makes $500,000 a year in gross income.
Saw something that suggested he pays in the order of $200,000 of that in taxes a year, which seems plausible to me. Here, I crunched the numbers using after-tax income, and under the Court of Appeals award, I come out with 36%, which it strikes me, tell me if I'm wrong, that given the change in the tax load, where alimony used to be pre-tax, taxable to the recipient and not to the person paying it, now it's post-tax, that's the appropriate thing. Look at after-tax dollars and then what's the percentage. And 36 is above the number in Gust, isn't it?
If I understand Your Honor's question, I'm not sure, and I don't want to misrepresent, but I think the bottom line is this court confirmed in remarriage of man, is the tax effect should be considered. But the point is, let's also look at Hancy's ability to support herself in the lifestyle that she has. She has independent wealth premarital. She got $411,000 cash, and also she said she wanted to go back to work and re-educate.
All the math you've done for what she has, alimony is not appropriate if a person can't pay it. I'd like to know, what is, in this 12 years, you've done the math you've sharpened the pencil and told us what she would get in her pocket, but you haven't said how much of that would be out of his, percentage-wise.
The reason why I didn't do that, Your Honors, again, my client is not disputing the fact that he can pay it with the $500,000. I mean, it's $90,000 a year. And so, yes, with his gross income, he can pay $90,000 a year. But in terms of when it's increased to the level of the Court of Appeals decision, then we get inequitable. Because, again, the Court of Appeals did not justify and did not explain adequately, in my opinion, why it increased its sufficiency. I see I'm set out of time. Oh, no, I can answer Your Honor's question.
Yeah, I'm going to raise this with Hancy's.
Okay. Thank you, Your Honors.
Good morning, Chief Justice, Justices, Counsel. Thank you for allowing me to be here today. I would like to first address a couple of questions that came towards the end here. There was a question about, you've done plenty of work calculating what Hancy would receive over the next 12 years. What would that look like for Surge? Well, if we looked at Surge's gross income at 500.
Close to the mic for Justice Oxley. Sorry. That's okay. Thank you.
Can you hear me, Justice Oxley?
Yeah,
Okay.
I can hear you.
Okay. If we just looked at gross income alone, $500,000 a year, assuming that there is going to be no increase, which seems unlikely based off of the historical earning capacity of Surge, that'd be $6 million. If we take a look at the net, and by that number, what I am considering is looking at the child support guidelines that we had put in. I believe it is at page 29 in the appendix, assuming that those numbers are correct, and just as you pointed out that you believed his taxable income would be right around $200,000 a year. I think it's a little bit less than that, but that's a pretty close. Oh, I'm sorry, apologies. It would be about $2 million.
Paid 200 in taxes, so it'd be 300.
Well, here's the numbers that I have, and they come directly from the court's order, the district court's order. After-tax income of $335,000, so that would have him paying $165,000 a year in taxes. That seems about right to me. All right, now if we do, it seems to me that given the change in the tax laws, what you're now concerned about is his after-tax income versus your client's after-tax income, because the alimony is now tax-free to the recipient but is taxable to the person paying it. And if we do that and we take the district court's award of $90,000 a year, that gets you to 31%, which is exactly the Gus number. So why should we go higher than that?
I think that Gust was saying that this is a ceiling by which it cannot be exceeded. I think you also have to look at what are his.
In Maurer, we also say that on appellate review, appellate courts should not tinker with alimony awards or spousal support awards unless there's a failure to do substantial justice. So if the district court's alimony award in this case roughly falls in line with kind of the historical precedents, I understand we don't have guidelines, but it's not outside the bounds of what's considered equitable in our case law, why should we tinker with it?
Would challenge that the district court's award was equitable. I don't believe that.
Numbers, it comes out to roughly 31%. And I can tell you from having decided many of these at the Court of Appeals, that is generally in line with how those cases are decided. So what is inequitable with an award that falls within the range of reason as evidenced by all of our case law?
Situation, not only would I argue that the amount was inequitable, but the duration was inequitable, and only classifying it as rehabilitative alimony was inequitable when this is a traditional alimony case. And despite
Fine with the amount that the district court awarded, but
I believe the appellate court had the correct amount, and I believe the appellate court also took into consideration that
answer this question though. If that award on a percentage basis is in accord with everything our cases say is equitable, our cases say that percentage is equitable, what is inequitable about this amount other than the assertion that it's inequitable? Like what case says that an award of 31% of the net difference is insufficient alimony?
case out there that I'm aware of, and in fact, I think that following the changes to the tax law, that the court has said that those types of percentages shouldn't be something that's binding. And I don't think it should be binding upon the court that you have to look at 31% and that's the ceiling. I don't think Gus said that. I don't think Mowers said that. I think that you also have to take into consideration what the appellate court did was that he is only going to continue to earn more money. And that is something that the appellate court did specifically find, that his income is only going to continue to increase.
12 years here. I mean, that seems like a very long time. Where does that number come from? I couldn't figure out where 12 years derives.
There was a two-factor consideration there. One was, as was pointed out earlier, right around the time that the children would graduate, which would allow my client then to continue on and be able to work more hours. Two, I was looking at Becker. When you're trying to define and present something to the court, I wanted to be able to articulate that, and what I looked at there was Becker, and that gave me the idea that this would, 12 years, would allow Hancy to complete her education, would allow Hancy to get a job, would allow her to move beyond an entry-level position, and be able to then become self-supporting. And that is what I took into consideration when I determined that 12 years. I believe...
Counsel, can I interrupt you? So speaking of Becker then, so the Court of Appeals awarded the highest $9,000 amount for 7 years. And I take it from Becker that that's kind of the rehabilitative part of the award. But in this record, it doesn't seem like it was going to take 7 years for your client to complete the master's program that she discussed. So why 7 years for that first?
Well, I think there's a little bit of confusion there. Hancy testified that the actual public health courses would take anywhere from 2 to 3 years. That's assuming she's able to do it full time, which she testified she did not believe that she would be able to do in also caring for the children. Not only that, that is just for the courses. Hancy provided testimony that before she can even apply, she would have to get her transcript and her records moved here from India, which was difficult to do because that school doesn't exist anymore, move here from India and then be approved. And only if they were approved, she would still have to go through undergraduate courses before she could even start working on her degree in public health. So that 2 to 3 year time period is accurate in the sense that that is the average time it would take a person working full-time to secure that degree, but that is not, when you look at the totality of the circumstances, how long it would take Hancy to do this. And that is why I believe that Justice, you are correct, is that 7-year part is more geared towards, even though it wasn't defined, rehabilitative alimony. And then I do have to disagree with counsel, both in his argument and in his brief, that traditional alimony was awarded in this case. Now, the appellate court didn't come straight out and say it, but if you look at the factors and the rationale that they gave, allowing Hancy to continue to live a lifestyle to which she has become accustomed, those are factors that you take into consideration when you are when you're looking at traditional alimony.
Our cases allow courts to kind of use a hybrid approach, some aspects of traditional plus rehab. Is this a case for transitional alimony?
As Justice McDonald has pointed out in his decision in Hansen and in the dissent, when you're looking at rehabilitative alimony, you're looking at a recipient spouse who requires a period of re-education or retraining to make them economically independent, to be able to go out and support themselves. That seems to be the key when it comes to rehabilitative. Is there a need for further education? Is there a need for retraining? Transitional doesn't seem to have that requirement. It's simply this spouse is going to need a short period of alimony in order to get them over that hump of transitioning from a married couple to a single couple or a single person, with the main factor the court looks at is income and what type of liquid assets that there are available. So I think that this, and which is why I argued it in the district court and before the Court of Appeals, this is a rehabilitative alimony case, and it doesn't fit within the transitional alimony as has been laid out in the Court of Appeals decisions.
Discussed hybrid type awards, and typically those are hybrids not including traditional alimony. It's kind of my assessment of it. It seems odd to say that you would combine rehabilitative alimony with traditional alimony, given that traditional alimony is usually defined as, you know, alimony up through retirement age or for life. Do you think that's an accurate assessment? And if you could combine them, how are we to gauge whether or not the award's equitable? Because now you have this kind of whole field of alimony awards of different ranges and time periods. How are we to exercise review of the time period if we don't have a specific category?
I want to make sure I understand your first question, which is, do you...
Sure, but go ahead.
Does Becker hold... I'm sorry, yeah, I just...
Looking at an award of alimony, and we have defined categories of alimony. When you're looking at these hybrid awards, how do you determine the equitable considerations, particularly duration? So here you have a 12-year award, and if it's just kind of an uncategorical form of alimony, how are we to judge whether or not it's within the range of reason? I mean, it could be 12, it could be 14, it could be 10. I don't think you could definitively say any of those are wrong if it doesn't fit into a categorical box. So how are we supposed to look at these awards of kind of odd duration, is how I'll call it?
I think, as this court has noted many times, looking at past precedent when it comes to determining these types of cases is really of little assistance. This is a traditional alimony case. If we were to apply GUST, that would be she would have permanent alimony up until the time that Suraj retired, and at that point, if it was unequitable, Suraj could come back for a modification action, okay? And I think that's appropriate when we talk about what many times we're dealing with in traditional alimony cases, where we have older spouses One has been out of the workforce for a significant period of time and is past that working age. In this situation, we have a long-term marriage. It's 17 years. We have and I've laid out in my brief, the factors of this case support a traditional alimony award except for the age of the parties. They're both young and they're both relatively healthy. And so I think that when you are looking at these types of unique fact patterns where you have a long-term marriage, but the marriage ends with their spouses are still young and in an age where they could go out and obtain employment, that you can not create, and that's not the word I want to use, but you can fashion a alimony award that not only addresses the long-term nature, the traditional component of it, but also recognizes that this is a younger couple, and in this type of situation, maybe not permanent alimony is appropriate.
You make a lot of good points. I mean, what you say is logical to me. The problem is, we still don't have an answer for where the Court of Appeals came up with their duration number from. How do you decide the length of this sort of traditional alimony light, as you describe it? I mean, what's the number? What's the formula? I'm troubled by doctrines that just tell judges kind of use your gut as to what you think is fair.
Sir, where did they come up with the 12 years? That was something that we requested, and I do recall being asked by the Court of Appeals why 12 years, gave the explanation at that time, and so that was something that...
Why 12 years?
Reasons. One, where the children would be at that point. Oh, I'm sorry. One is where the children would be during that time period, close to graduating from school. And then, like I said, two, I was getting inspiration from Becker. I was trying to formulate a proposal to the court that not only recognized the rehabilitative needs that my client had, but also the fact that this is a traditional alimony situation, and would the court be receptive to awarding lifetime alimony to a 41-year-old woman? And I was trying, that's where it came from, the age of the children, when they would be completing school, and then looking at Becker and formulating what I thought was a proposal that would get her through those difficult times. And I've gone past, may I just finish?
Best answer this question: is $90,000 a year tax-free sufficient for her to enjoy the lifestyle to which she had become accustomed during the marriage? And why not?
Affidavit, which I did misstate in my brief as on page 92, 93, I believe it's on page 22, 23. Her basic monthly expenses are $12,000. If you take out the non-variable components of that, but then you add in what she would need for tuition, which was the basis of the rehabilitative alimony, that's at $10,000, $10,000 plus. So the answer to that question is no, it does not cover her basic needs.
Thank you.
Your Honors, may it please the court. I think this case provides an outstanding opportunity for this court to clarify Becker, because I think since 2008, when Becker was issued, what has happened is that district courts, the Court of Appeals, and frankly attorneys advising clients have been misreading Becker and have misapplied Becker in terms of coming up with whatever, I guess, the gut instinct, which I think is extremely problematic. And going towards Justice McDonald's points in his opinions in Hanson and Beckham, I think transitional alimony recognized that this court will clarify Becker. Why is that? It's because Becker has stretched traditional and rehabilitative definitions, blurred the lines between those alimonies so much that, frankly, we don't know what it means anymore. Because granted, it's hybrid, but We've got potentially a long marriage, we've got income disparity, but then they don't want to go back to work or they do want to go back to work. And so when you focus on those 4 classes of alimony by this court adopting transitional, it will significantly remedy a lot of the problems that have arisen since Becker this particular time. Now, $90,000 a year, Justice.
Mr. Howie?
Yes.
Mr. Howie, so in your view of transitional alimony, would that include any kind of award to allow the spouse to go back to school, or is that simply get them set up in separate households?
Well, in terms of the transitional alimony definition as offered by Justice McDonald in his previous opinions, is that transitional comes in when you have a recipient spouse who is capable of self-sufficiency, but does not have the liquid assets to support him or her in terms of when to transition from married life to single life. Rehabilitative.
Counsel, so in this particular case, then, are you saying that currently Hancy is able to support herself without going back to school at the level that he has been?
No, I appreciate your question. The answer is no. That's, again, the district court awarded rehabilitative alimony. My client accepted rehabilitative alimony. It's clear in the record she was planning on going back to retraining, re-education, whether she got the master's in public affairs, which took 2 to 3, at most 5 years, or if she wanted to return to the medical field, she admitted that she would take about 7 to 8 years. And so even when you take Hancy's own testimony and evidence, the 12 years is unjustified. There's no basis for it. The 5 years perfectly fits into her own testimony as to what she intended to do post-divorce. Now, is the $90,000 a year tax-free income, alimony, sufficient to support her lifestyle? The answer is yes, because based upon her own numbers in terms of what her expenses, that $10,000 to $12,000 of monthly expenses included almost $3,500 a month in educational expenses. And so why should Suraj, post-divorce, continue to have to pay more and more and more based upon those decisions? Again, divorce is supposed to be final. We're done. We're moving on with single lives. Also, what's completely unjustified is why the Court of Appeals made the first 7 years non-terminable if she got remarried. That means she could potentially be supported by 2 spouses, which is unjustified. So the Court of Appeals, unfortunately, just, I think, misinterpreted, misapplied this case, this court's well-established jurisprudence on the topic. And as Justice McDonald did in Bacam and Hansen, transitional was discussed. There's a lot of case law that goes in there, and I certainly don't want to speak for you, Your Honor. Your opinions speak for themselves. But you went through the analysis and said transition, even though it could, it still doesn't apply. And this court could do that as well. This court could adopt transitional alimony and just say, you know what, actually transitional doesn't work here, but rehabilitative does.
Interrupt you for a moment. You're talking about the alimony that was originally ordered by the district court would be more than sufficient, and that it included $3,500 per month for education. Show me on her affidavit of financial status. I'm looking at the appendix, page 25 and 26. Where do you get those numbers?
Those were specifically on 92. I think my esteemed counsel corrected herself, but those was what I was going on in terms of her original appellate brief to the Court of Appeals as to what her numbers were. It was $10,441, if I remember correctly, and $3,500 in terms of the actual expenses. That's what she put in her brief, which was based upon, I think, what she testified to in terms of her planned on education. Again, this is not a traditional alimony case. She's only 41. She's healthy. She wants to go back to work. And if this court, for example, considered traditional alimony, if she lives to the age of 76, does that justify 35 years of alimony? No. Not under the statute, not under the case law.
So her likely income would be after she gets her master's.
An estimate based upon, I think, Hancy's testimony. She said on the low end she would make $25,000 to $30,000 a year. On the high end, she expect to make $70,000 to $80,000.
Thank you.
Ask this court to vacate the Court of Appeals on alimony and affirm the district court. Thank you, Your Honors.
Thank you. The case of marriage of Pazhoor is hereby submitted, and The next case we'll hear in oral argument is Union Pacific Railroad versus Drainage District 67.